Is it better to have a will or a trust? Hi, my name is Alain, and I'm a estate planning attorney based out of Doral, Florida. So, first of all, let's talk a bit about what is a will and what is a trust. A will is a document where you select who are going to be your beneficiaries at death. A will does more than just selecting the beneficiaries. A will would also nominate a personal representative here in Florida. The personal representative is somebody appointed by the court based on your designation to represent your state through the probate proceedings. The personal representative will be in charge of paying any creditors, administering your assets, making distributions. In the will, you can also designate who are going to be the guardians of your minor children if both natural guardians are no longer here. Also, obviously, that only applies if you have minor children. So let's talk a bit now about a living trust. A living trust is a document, it's a legal fiction where the title of the asset changes from your own individual name to the name of the trust. When you create a trust, you also designate a trustee. The trustee is the person in charge of administering the trust. Typically, during your lifetime, you are going to be your own trustee. If you ever become incapacitated or when you pass away, you will designate basically a successor trustee. So when do you need a will? When do you need a trust? And the answer is, it all depends on the assets that you have and if you have minor children. In Florida, only assets that are owned individually by you with no beneficiary designation or a survivorship provision passes through probate court. Typically, the main purpose and goal of creating the living trust is to be able to avoid probate court. So let me give you a couple of examples. If you have a bank account, if you have an individual retirement account, if you have a life insurance, all of those things have a beneficiary designation, meaning that when you pass away, you write down in your bank, you fill out a form, and you designate who's going to be the beneficiary upon your passing. That money, those funds, passes outside of court, meaning that you don't need a trust in order to avoid probate court. A trust in order to avoid probate court for those assets. However, if you have assets that are individually titled to you, let's say you have an investment property that you bought that's going to be under your own individual name, that's going to go through probate. Also, your homestead, if your homestead is titled under your name, that would also, it's going to get probated, although it's not a probate asset. So once you determine the type of assets you have, and if you determine that all of your assets are not going to be probated, they're not going to pass through probate court, then you might not even need a will or a trust. But if you find out that you're going to have assets that are going to be probated, meaning that they're going to pass through probate court, then at a minimum, you should think about creating the will. If you do decide that you want to create a will, then know that your beneficiaries are going to have to go through probate court and do that whole administration. If you go through probate court, you're going to have to hire a probate attorney. And let me tell you, those are not cheap. A typical formal administration probate case, and a probate attorney will charge you anywhere between $3,000 to $10,000, depending on the complexity, depending on the amount of assets. So for the most part, you want to avoid probate, and not only for the money, but also the asset itself is tied into the court system for a minimum of 6 months. I've seen it go as long as 2 years. In addition of probate avoidance for the trust, if you find that you have probate assets, then you have to take a look at your family dynamics. Do you want your beneficiaries to receive all of the assets immediately upon your passing? Meaning that if you have your bank accounts, your individual retirement accounts, your life insurance, When you pass away, if those have a beneficiary designation, they're not passing through probate, but your beneficiary is going to receive those assets immediately upon their passing. If you're okay with this, then there's not a lot that you need to do. A lot of my clients and what we estate planning attorneys advise is to create a trust. And the reason for this is that with the trust, you have a lot of control. With the trust, you can make it so that once you pass away, your trust will last for 20 years, 30 years, couple of generations. Make sure that your son and your grandsons are taken care of, for example, for their education, for their health. So if that's something that's appealing to you, then creating the trust is going to be the best option. What you do is that you title the bank accounts, the life insurance, make the beneficiary your trust. And at that point, you choose in your trust how that money is going to get distributed. Do you want to wait for your kids to turn 35 in order to receive the money? Do you want your kids to receive the money when they're 40, when they're 45? But you will think, oh, but I want to make sure that my kids are taken care of. I don't want to wait till they're 45 for them to receive the money. Well, there's provisions that we can add into the trust so that they can get money periodically, meaning that they can get all the income from the trust every year, so that they can also withdraw principal from the trust based on specific events like marriage, getting a business, having a child. So there's a lot of options in the trust that you will not have with your will. So, and especially if you have minor children, because in Florida, if a child receives an inheritance over $15,000, then you're gonna need guardianship court. But if the child receives over $15,000 in a trust, then you will not need to open up a guardianship, because your successor trustee, the person in charge of administering the trust, is going to be in charge of administering the money for your minor child, thus avoiding guardianship court until the child turns 18. Typically, if you do give a will, the child receives $50,000, you're going to need to open up a guardianship. The guardianship is going to need to be open until the child turns 18. You're going to need annual accountings. You're going to have to hire a guardianship attorney. And in addition to that, upon your child turning 18 years old, he's going to get all the money. So do you need a will or a trust? I went on a little bit longer than I really wanted, but I think you needed to hear the long answer. I feel that if you want control and you don't want your beneficiaries to receive all your assets immediately upon your passing, then the trust is the best choice. The trust should be also the best choice if you have minor children. If you're not going to do anything, then I feel that at least you should have a will, because that's going to make the probate process a lot simpler. But if I had to choose, I will tell you that usually the living trust is the best option. Hope you find this video valuable. You can follow me on social media at Alain Law. See you in the next one.